Hi, everybody out there. This is James Owen, Executive Director of Renew Missouri, joined silently by our webinar producer, Tori Cheatham, out of our St. Louis office. We are going to be talking today about exploring legacy building with Renew Missouri. It's a webinar on plan giving strategies. This goes along with a mailer that we sent out a few weeks ago where we were asking folks that have been generous with Renew Missouri in the past about whether or not they would consider a long-term legacy gift to Renew Missouri. And we wanted to talk a little bit about that and explain how that might work. Now, before we get started, it needs to be very clear. This is my disclaimer that while I am a lawyer, if you are listening to this, I am not your lawyer. I am not giving you confidential legal advice. We are not establishing an attorney-client relationship here. What I am doing is I am providing education and information about estate planning, about non-probate transfers, about annuities that hopefully you can take to your legal professional or your accounting professional, and you can talk to them about the things that you heard here today and maybe use this as a starting point for developing your estate planning or your asset planning or your gift planning. So very clear, I am a lawyer. I am not your lawyer. Okay, we all cool with that? Everyone happy? Great. All right, next slide, please. So this is being presented by Renew Missouri. So we should talk a little bit about who Renew Missouri is. We are a 501c3. That means we are an IRS recognized nonprofit that focuses on clean energy in Missouri. We work on renewable energy. We work on energy efficiency. We work on battery storage. We work on electric vehicles. And increasingly, we are working on generally access to clean energy to help disadvantaged and otherwise socially barred communities to have the same benefits that more affluent customers have had the privilege of being having access to. We have done this for close to 18 years. We were founded in 2006. We largely do this work through legal advocacy through the Public Service Commission, which regulates companies like Ameren, Evergy, Liberty Empire, and we intervene in those cases. It requires a number of us to have legal degrees, advanced degrees. It takes a lot of education and training to do that work. It's very specialized. We also work with rural electric cooperatives and municipal utilities on energy-related topics. So if you're a municipal utility, we are often working directly with the utility itself. Or are we working with city council members in those areas? That would include Springfield, Columbia, Independence, Kirkwood. Those are the large municipal utilities, but there's about 88 of those around the state. And we tend to generally work with the other ones through the Missouri Public Utility Alliance. There's also rural electric cooperatives. We try to work directly with the member owners of the rural electric cooperative to make sure they understand what their rights are in that system and what options their co-ops should be pursuing. While we are limited by IRS rules about what kind of lobbying we can do, Renew Missouri does have a presence in the Missouri Capitol. We do lobby on various issues involving clean energy, involving renewable energy, involving energy efficiency, and involving matters trying to oversee and maybe perhaps limiting the authority of the Public Service Commission. We are involved with all sorts of matters like that, but in a limited sense. Moreover, while we receive a lot of grants for the work we do, we can't rely on those grants for the work we do in the legislature. We have to rely on private funds for that, which is one of the reasons why we seek solicitations from individuals and businesses, because that helps fund our presence in the Capitol building. So that's why that's really important. Next slide, please. You might be asking at this point, who am I? I have said I am the executive director of Renew Missouri. I'm kind of generally the face and the person who runs this organization. We have a lot of professionals who make this place work. and it makes it successful, including Tori. She does a great job for us in our St. Louis office, especially with some of our policy outreach and education efforts. She's very good at that. I am a lawyer, as I mentioned. I used to practice in estate planning and estate administration. I did that for a number of years in the Southwest Missouri area. I was based out of Springfield, Missouri. My firm also had an office in Marshfield, Missouri, which is where I'm from. That's where my family farm is located in Webster County. So I'm a farm kid originally. I was also a judge in Webster County for a brief period of time. I was an associate circuit judge there before my wife and I moved to Jefferson City, where I worked in government. And that included being the former public counsel for the state of Missouri, where I represented Missouri ratepayers before the Public Service Commission. It's kind of where I got to know a little bit about energy policy and utility rate making, which is the experience I was able to bring to Renew Missouri. So that's me, James Owen. That's a headshot of me. It's from 2012. I need to get that updated. Don't send me letters. Next slide, please. So what's on our agenda for today? Well, we're going to look at what plan giving is, why it's important. We're going to look at Renew Missouri's new plan giving program, and we're going to look at the types of gift giving that you can make as a part of this. Again, as a reminder, this is just for educational and information purposes only. This is not legal advice. Very important. I keep saying that. Next slide, please. So what is plan giving? Okay, so the way Renew Missouri raises money, we have a couple of different ways of doing that. We apply for a lot of grants from foundations, from the government, from other charities who are interested in the same things we're interested in. We get those grants sometimes we don't. We also work on individual donations from corporations, from other entities. That can be a solar company, that can be a wind company, be an energy efficiency contractor. We have a lot of supporters at that level, but we also have a lot of individual supporters. I was just looking at individuals who give us more than $200. We have about 67 individual donors who give us more than $200 every year. Some give us much more than that, but we have about 67 that do that, and we have a lot more than that who give us $100 or less. So we have a lot. I would say that probably puts us up closer to 200 donors from that level. You can look at our Form 990s. The last one we filed shows that we have about $1 million in revenue that we brought in last year, and a lot of that comes from grants. Some of that comes from corporate sponsors, but a lot of that comes from individuals. That's how we usually get money. There is a approach that we have not done previously, where we talk to our donors about the idea of being able to leave us a gift that would be in your estate plan. So when you pass away, you would be able to leave us a one-time gift or a continual gift in your trust or your will or some other means, and that would be another way of funding our work. It is not something we have tried before. It is usually reserved for pretty large entities, but we have had some questions about it. We've had some people that have expressed interest in it. And so I just thought it would be good to try to make it a formal program. So the gift usually only works if you have a well-executed estate plan. So that's what we're going to talk a little bit about on this webinar. Next slide, please. So why do it? We've already talked about that. We talked about the work we're already doing in front of the Public Service Commission with municipalities, with rural electric cooperative member owners, the lobbying work we do. I mean, generally speaking, this money that we would be soliciting through a gift plan would probably be something that we'd put in a reserve account that would be interest bearing. And so it wouldn't just be a one-off. It would not be something that is just going to be used for the year that we receive it. It would be something that would build to a larger endowment. That is something that we could, eventually have income for the interest. So we're not looking at this just as, oh, we're going to pay the utility bill with this gift. We would be looking at this as being a separate matter, and potentially eventually this starting out in a reserve account, but it becoming something larger and more structured, like an endowment. But we're not really quite at that point yet. We want to be able to raise some money before we get there. This is important because we want Renew Missouri to be doing this for a long time. We've been doing this for close to 18 years. I think that Renew Missouri can have a lasting long-term impact on the state, on the Midwest, and on its citizens, and on the planet. And I think that that needs to continue going. So that's going to allow us to do that after we're gone, after I'm gone, after you're gone. And so I think that's going to be important. So next slide, please. And sorry if you hear me sniffling, it's because I've still got a little bit of a cold. So don't worry, my estate planning is up to date. So what we're going to do, we're going to really focus on gifts of less than $100,000. It would be very surprising to me if somebody was coming to us saying we want to have a gift plan of more than $100,000. If that is the case, you need to call me or you need to email me, and you need to put me in touch with your lawyer so we can work out what that would look like. But we're looking more like, what would a $5,000 or $10,000 or 15 or something like that, what that would look like. And one of the things that Renew Missouri can provide assistance on and provide guiding language on is usually going to involve either a trust, a last will and testament, or a non-probate transfer. Those largely, when we're talking about estate plans, those are three of the various tools that we can use to tackle how you're going to leave your gifts moving forward after your death. And really, one of the things I would note is whichever one you pick, it's going to be based on a couple of different factors. The first factor is, what are your assets while you're alive? Are they complicated? Which is to say, do you have property in multiple counties or multiple states? Are you receiving structured payments from litigation or from another trust? Do you have stocks? Or do you just have a house, a bank account, and a car? And to me, like, there's different tools that will address either one of those types of asset of the type of assets you possess. Are they complicated or are they simple? And then the second question is, excuse me, well, are your instructions and who you want that to go to, are those simple or are those complicated? Do you have a lot of different instructions that need to be followed in order for those assets to be given out? And though the answer to those two questions, the nature of your assets and the nature of your instructions, are going to play a big part in the type of estate plan you want to have. Next slide, please. Ways to give up to $100,000. We have a graphic and everything. Next slide. Okay. So the simplest way of dealing with this is through non-probate transfers. Can we go to the non-probate transfer slide real quick? Okay. This is what I want to go to first. Okay. So in 1989, the Missouri legislature basically said that individuals can avoid probate, avoid trusts, and have a more streamlined way of leaving assets to their loved ones or to a charity or to some other entity through what is called a non-probate transfer. And there's a couple of different types of non-probate transfers that Missouri law deals with. Let's say you own a house. If you own a house, and let's say you're 80 years old and you have two adult kids. You're widowed, you have two kids, and you want the two kids to have the house. The easiest way to dispose of that house, if you just want your two kids to split it, is to do a beneficiary deed on the house, which you have to record, that says, upon my death, they are going to own the house. And that's a beneficiary deed. If you have a vehicle, you would need to go down to the License Bureau, Department of Revenue License Bureau. And if you have a title to your vehicle, which you should almost certainly have a title to your vehicle, you are going to have what is called a transfer on death designation on that title. And whoever you want to have the vehicle will then you just need to put their name there, and then they're going to be listed as the TOD designee. That's the phrase. So let's go back to our example of where you're 80 years old, widowed, 2 adult kids. You want your 2 kids to have the car. You put their names on it, and then when you die, they are the owners of the car. They just got to go to the License Bureau and present your death certificate. And then let's go to the payable on death. There we go. Then on your bank accounts, you go to the bank. Usually when you're setting up an account, you will be asked, do you want this money to go somewhere when you die? And that's a payable on death designee. Let's say we'll go back to our hypothetical. You're 80-year-old widow. You have 2 adult kids. You can put those 2 adult kids as POD designees on there, and they would get that money when you died. And all you'd have to do is, again, your kids would have to go to the bank and present that death certificate, and that's how that would work. You could also do that with a charity. You can also do that with a church. You can also do that with whoever. But you usually do that for loved ones, relatives, etc. It's really straightforward. You maintain control of the account. And that's an important point, because a lot of times people will put other people as the owner of the checking account or the savings account. And when I say owner, that means that the other person's name or the children appear at the top of the check. That I think invites trouble, because if you're the co-owner of an account, you can write checks. You would get that money when the other co-owner dies, but you can withdraw money. And so if your money is going into that account and that person that you've got listed as the co-owner is taking it out, there's literally nothing you can do to prevent them from doing that, even though it's your money, quote unquote. The bank sees it as the money listed as the co-owner, So that would be a problem. But if, like, let's say you wanted to have someone helping you with that sort of thing while you were alive, the best thing to do would be to execute a durable power of attorney and have them do it that way. There is limited access to that too for that person. So having a durable power of attorney is a way of doing that. Now, Tori, can we go back to that other slide about the non-probate transfers real quick? Okay. So you can do a TOD, you can do a POD, you can do a beneficiary deed on your house. Now, what is really important to know about this is that if you do a will or you do a trust, and let's say you leave your house through a beneficiary deed to your 2 kids, you leave your bank account to your 2 kids, and you leave your vehicle to your 2 kids, and let's say you have a will where you leave everything to Renew Missouri, that will is going to have no control over those assets, because when you died, those are all going to immediately transfer to your 2 kids. Okay. The probate court, for which we write wills, the only thing that really a last will and testament does is provide instruction to the probate court about what to do with someone's assets when they die. And the only assets the probate court is concerned with are the assets that remain in your name upon death. If you have a beneficiary deed, if you have a TOD on your vehicles, if you have a POD on your car, that is not going to be in your name when you die. It's going to go to your 2 kids. So the will's not going to matter. And the trust, if you have a trust, and let's say you leave assets to, let's say, a charity or your church in your trust, but all of your assets, your bank accounts, your vehicles, your property are all POD'd or TOD'd or have a beneficiary deed to somebody else, that trust is not going to be able to administer that either. Now, what some people do, or what you really should do, when you have a trust, and we'll talk more about a trust here in a second. If you have a trust, the trust can hold the property, it can hold the bank accounts, it can hold title to the vehicles. It can also be there to be a non-probate designee on your property. You can leave the trust your house in a beneficiary deed. You can make the trust your payable on death designee. You can make the trust your TOD designee on your title. It can work that way. You don't have to fund your trust until after you die. And that's the way you do it. And I will tell you as an example for why that would be. Let me give you an example of that. Let's say you set up a trust and you want to put your bank account in that trust. The bank is almost certainly going to make you close your existing accounts and create a new one in the trust's name, which is a little bit of a pain in the neck, let's be honest. But if you just change the designation to the trust, then you don't have to do that. So that's just one example of how that might work. And I should also note that, again, with the non-probate transfer, we're going to go back to the non-probate transfer. You can leave your loved ones that money, or you can leave it to a charity. So it can work that where, say, for example, if you had like a $10,000 savings account and you wanted that to go to Renew Missouri, you could name Renew Missouri Advocates Incorporated as the designee on that, and that would come to us when you pass away. Okay, next slide. Okay, let's talk about wills and trusts. I've already talked about them a little bit, but I want to get into more detail about that because this is really important. Again, and I cannot emphasize this enough, a last will and testament is nothing more than your instructions to the probate court about what you want done with your assets that are in your name when you die. If your house is in your name and there's no beneficiary deed, or there's no trust that holds the house, if you have bank accounts that do not have a payable on death designation, or they're not held by a trust, or you have vehicles or stocks or anything else, the last will and testament is only going to concern itself with whatever is in your name when you die. That's it. Like if you have a POD or a TOD or a beneficiary deed, that will is not going to matter. And I know there are people out there who write wills believing that it's a direction to the people they're leaving their assets to through a POD designation or a TOD designation. No, that is not how it works. Those assets in your name after your death, something has to be done to deal with them. That's what the probate court is set up to deal with, to dispose of and to wind up business for a deceased person involving any and all assets that exist in their name at the time of their death. That's it. That's all it does. It appoints a personal representative, which you may know as an executor. That might be kind of a common way you would, call that person. And it says, well, here's how I want this left. I want it left to, like, let's say my two kids. Let's say you're this 80-year-old woman and you don't have a beneficiary deed, you don't have a POD, you don't have a TOD designation, but you have a will. And you say, okay, well, I want my daughter to be my executor, and I want my son and daughter to receive all of my assets. So then that means that the house, the bank account, and the vehicle all go to probate. And you've got to do an inventory. You've got to like give creditors notice. You've got to do a lot of hoops to jump through. Oh, I should also, in this scenario, I should mention, you can also put in your will something that says along the lines of, oh yeah, I'd also like for Renew Missouri to have $5,000 or whatever. So the probate court is there to ensure that your executor follows the law and make sure that everything is done in accordance with the Missouri probate code in the administration of the estate. And then when it's done, they oversee the distribution of that estate to whoever's listed in the will. So let's say it's a son and daughter, plus there's a specific bequest to Renew Missouri for $5,000. The probate court is going to make sure that that gets done in accordance to what the person wants done in the will. So that's what a will does. Next slide, please. So what's a trust? Well, a trust is, I mean, it's basically a contract. You're creating a legal fiction that is going to hold your assets. And it will hold your assets while you're alive, and it will continue to hold those assets after you die. And you will, so basically, here's how a trust works. You have a lawyer write it up. It does the same things a will does. It appoints a trustee. It says what you want done with your assets when you die. And it basically governs how all that works. Now, when you do the trust, I always say it's like a lot like a shed. You can build a shed for all your stuff, but unless you put your stuff in it, it's going to get wet when it rains. So you've got to take efforts to put stuff into your trust. Your property goes into your trust. You can deed your property to the trust. Your bank accounts can go into a trust. Your vehicles can go into a trust. Your stocks and securities can go into a trust. With a life insurance policy, as an example, you don't want the life insurance to be the owner of the trust. No, you don't. Yeah, you don't want the trust to be the owner of the life insurance, but you do want the trust to be the beneficiary of the life insurance policy, so that gets funded after you die. It is essentially established there for all of your earthly possessions, for all the things you own, and then when you die, your trustee takes over and makes sure that gets followed. The probate court does not get involved with the trust. It is all private. None of it has to be public. I mean, you have to give notice in like local paper of record, but ultimately everything else is private. It doesn't go into the court paperwork or anything like that. It is handled by the trustee and by the beneficiaries. So let's say you have a trust, you put your house, you put your vehicles, you put your accounts into that. You say you want Renew Missouri to have $5,000, but you want your son and daughter to have everything else. The trustee has to make sure that happens. Now, I would say that if you just have a house and a bank account and a car, you should not do a trust. I think trusts really should only be reserved for when you've got complicated and more expansive. I think when you have expansive assets, like let's say you have investment accounts, let's say you have businesses, let's say you have multiple pieces of property that expand over multiple jurisdictions. That's when a trust comes in handy because those are complicated. Or like, let's say that you want a charity like Renew Missouri to get only $5,000 per year. An estate through a will is set up to only last a very limited amount of time. Really 9 months to 12 months at most, if you're doing it correctly. A trust can go on forever. And so if you want to just have like a little bit here, a little bit there, again, complicated instructions, complicated measures for how you distribute it. That is what a trust would be important for. And that's why I would advise my clients when I'm a lawyer. I still practice law on the side, but when I was full-time, I would advise them that if you don't have complicated assets, there's really no need for a trust. That's very different than what a lot of lawyers say. A lot of lawyers tell people just to do a trust no matter what. I tend to think it's a little expensive for that. I think if you've got real simple assets and you got real simple instructions, you don't need a trust. But that's just me. So anyway, that's my take on that. Next slide, please. So then there's also the charitable bequest. And so this is where I think we can help. Like, let's say you want to do a will, you want to do a trust, but you don't know what that language should say. We can provide that, and you can go take that to your lawyer and they can incorporate that into your will or your trust. And so we have an example. You can look at it. And we can help, but we would prefer to help your lawyer or your accountant or whoever you have helping with it. So you can look at this bequest down here. I'm going to read it so you see what it says. I give, devise, and bequeath to Renew Missouri, a Missouri nonprofit corporation, and a qualified 501c3 organization located in Columbia, Missouri, federal tax ID number 81-322-9949, the sum of blank or percentage of my estate, or other personal property herein described to be used for its general programs and advocacy, education, and outreach as it shall determine. Okay. The reason we write it like that is, one, we want to make sure it's very clear which Renew Missouri we're talking about. That's why we have the information about the federal tax ID. We have the location. We want to make sure we're not confusing that with any other entity. Also, another reason we have a percentage of the estate on there instead of just a lump sum is, like, let's say you leave $90,000 to Renew Missouri, but it ends up that you only have like $80,000 in your estate when you die. So, but you also wanted your kids to get some money too. So then Renew Missouri gets everything. But if you said, like, well, I want Renew Missouri to have 10% of my estate, and let's say you had $100,000, it would get $10,000 or whatever. You can do it like that too. So that is something you would have to decide. That's something you could talk about your lawyer, but that's the language that we could offer, that we could make sure that your lawyers are aware of, that you could put into your will or your trust. Or if you have a will and a trust, you can use this as an amendment. So that's just an example of what you could use. Again, not asking you to put this into a legal document, not saying this is what you should rely on, but this is something you could show to your lawyer, show to your accountants, and you could use this. Next slide, please. There's also gift annuities. This is usually like where you would have like an investment account, or you'd have like some sort of securities, where you could have this set up to where it gives money over time. This is something that you want to talk to your accountant about. You might even be able to talk to an insurance person about this, because this can also be done through life insurance. By looking at the looking at the IRA, which, by the way, I should mention is not the same thing as the Inflation Reduction Act that we always talk about here, but this is more of an investment account. You can have an IRA account that can make a one-time gift up to $50,000. And you could even start doing that after you turn 70 and a half. So it even wouldn't have to worry about when you die. This could be a charitable gift that you give while you are living. But again, it is not something you would have access to while you're alive. There are age limitations to it, but there's also tax advantages to it as well. Certainly we would suggest you talk to your financial advisor or your accountant about that. Next slide, please. Okay, and then, while we were talking about a basic revocable trust, there is also the remainder, a charitable remainder trust that you can set up that would allow you to place an annuity in that, or a life insurance policy. It provides that you or other named individuals with income each year for life or specified period, not to exceed 20 years, where the remaining balance could go to Renew Missouri. That's called a remainder. That remaining balance is called a remainder. That can be an annuity trust, or that can be a unit trust. It pays a variable amount based on trust assets market values. There's a good income stream there. There's tax benefits to it. But again, if you're wanting access to your money, same way as the problem with the charitable annuity, you would not have access to the money, and you would not be able to change that once you establish it, because it would be irrevocable, which means can't change it. Okay, next slide, please. And there's also securities. That's a stock. That's a bond. You can give those to Renew Missouri as well. It can help you with any kind of capital gain tax issues that you've got on your securities. You can do a non-probate transfer on death for that. That would usually be a beneficiary designation, or it can just be an outright gift. Renew Missouri does have a brokerage firm with Central Bank of Boone County, where we have received securities as a gift in the past. And so we are set up to be able to do that moving forward as well. Benefits of that is federal income tax deductions. You can get benefits on your taxes on that. That's not just for your federal income tax, but that's also a capital gains tax as well. So if you made too much money on the stock market, you would be able to gift this away, and that would be able to help with that liability. But it does get immediately distributed after the account owner is passing. And again, there's not much you can change about that while you're alive, and that there would not be a lot of wiggle room with that. Next slide, please. Oh my gosh, is that it? Oh, we did that in pretty good time, didn't we, folks? If you have any questions, I know that we're doing this as a recording. You can contact me at james@renewmo.org, or you can call me directly at 417-496-1924. You can follow us on Facebook, Instagram, LinkedIn, or YouTube. But again, if you're interested in doing this, if you have any thoughts about doing this, we'd like to talk to you, or talk to your lawyer, or talk to whoever is helping you with your financial planning. And if you are so willing to do it, one, we want to say thank you from the bottom of our hearts. And two, we want to make this something that actually works. So please consider giving us a call or emailing us, and we'd be happy to help. That's it. Thanks again.